Welcome back, everyone. Our last panel for the 8th Harvard International Arbitration Conference will be discussing the differences, if any, between common and civil law traditions in the enforcement of awards. Our very first panelist is Dana Mcgrath. Dana is currently a full-time independent arbitrator and formerly spent 2 decades acting as counsel in arbitrations and award enforcement proceedings at several global law firms. She is also president of Arbitral Women, a proud supporter of the 8th Harvard International Arbitration Conference. Our second panelist for the day is Adrián Magallanes. Adrián is co-head of the Arbitration and Litigation Practices of von Wobeser and Sierra in Mexico, and co-leads its Energy and Natural Resources Industry Group. He is also part of the Environmental, Social, and Governance Practice Group. With close to 20 years of experience, he is described by Chambers and Partners as an extremely talented practitioner, a great advocate, and an excellent strategist. Our third panelist for the day is Leah Njoroge. Leah is a legal counsel on one of the case management teams of ICSID. She joined ICSID in March 2019, and prior to joining ICSID, Leah worked at an international arbitration firm in Nairobi in Kenya. Leah has a strong background in international law and holds a master's degree in international law and economics from the World Trade Institute in Switzerland. She is admitted to practice law in Kenya and holds an LLB from the University of Nairobi. Many thanks for the three of you for accepting our invitation today, and I leave the floor to our three panelists, and in particular to Leah to kick off this panel.
Thank you very much, Karim. And to start us off, I'd just like to say good morning, good afternoon, good evening from wherever you're joining us from. It is indeed an honor to be among esteemed colleagues, friends, and guests, and people I know from the international arbitration community around the world. Thank you for inviting me, and I'd like to express my gratitude on behalf of ICSID and the organizing committee of HIALSA for inviting me to be part of this conference. Marianne, Sebastian, and Karim, thank you so much. As you've been told, my name is Leah Njoroge. I'm legal counsel at ICSID based in Washington, D.C. Our panelists who've been already introduced to you are Adrián and Dana. And we are the last panel of the day and of the conference, and we certainly look forward to an exciting and engaging session looking at the topic of enforcement of awards and local courts, a dialogue between traditions and the New York Convention. I mean, before we begin this panel, we structured it to be very interactive. And the intention is that our speakers will draw from their extensive background to offer their views in keeping with the conference theme of being clash of cultures, civil and common law. Are there any differences? And we certainly hope our very experienced panelists will be able to help us draw a conclusion to that question. Adrián will gladly offer his perspective from a Latin American and civil law background, and Dana will jump in discussing common law perspectives, in particular the US court's approach. So without spending much time, let me straight go into asking Adrián, does the coexistence of the New York Convention alongside the Panama Convention and the Montevideo Convention generate issues for Latin American enforcement courts? And over to you.
Thank you, Leah. It's a pleasure to be here. Thank you very much for the invitation, Karim, Sebastian, and the organization committee of HIALSA. This conference is always fantastic. My kudos to all the students that put it together. It is an amazing conference. The short answer, Leah, is yes, but only to some extent. And please let me give you some context. Historically, Latin American countries showed reluctance towards international arbitration due to various reasons, among others, the decolonization process, and also the need to safeguard their economic independence. However, Latin American countries' attitude began to change in the 70s, first through a regional approach and then through a global approach. In this context, the Inter-American Convention on International Commercial Arbitration, known as the Panama Convention, was adopted in 1975. It sought to promote international arbitration in Latin America, also to modernize the then deficient national arbitration laws and to consolidate the region as an independent, and the idea of independency was important in that context, actor in the field of international arbitration. Many Latin American states, such as Paraguay, Honduras, or El Salvador, choose at the time not to be only be part of the Panama Convention and not be part of the New York Convention. In the case of my jurisdiction, Mexico, the situation was a bit different. Mexico entered the New York Convention earlier than the Panama Convention. Now, today, most Latin American countries are parties to both conventions. So when enforcement is sought between these states, the question of parallel application and treaty conflict may arise. Now, this parallelism may be considered a particular feature of recognizing and enforcing arbitral awards in Latin America. To complicate things a little bit further, there are two other regional conventions that also deal with the recognition and enforcement of judgments and awards. First, the Inter-American Convention, known as the Inter-American Convention on Extraterritorial Validity of Foreign Judgments and Arbitral Awards, known as the Montevideo Convention, and for the Mercosur states, the Protocol of Las Leñas. Now, the Panama Convention does not establish what its relationship to other treaties is. However, the New York Convention contains a compatibility clause in its Article 7.1, which makes it clear that the New York Convention does not exclude the application of a more favorable law treaty of convention. Thus, if both parties are in a dispute, are subject to the Panama Convention, and its application leads to a result more favorable towards enforcement, the Panama Convention prevails over the New York Convention in case of a conflict of norms on the application of the treaties. Now, in this context, the application of Article 30 of the Vienna Convention on the Law of Treaties, governing, as you know, the application of successive treaties relating to the same subject matter, would lead to a similar result between between these two conventions, to the extent that they relate to the same subject matter. And here, the Panama Convention, it's more international in the sense that it requires the arbitration to be, it requires the award from which the enforcement is being sought to derive from an international arbitration, whereas the New York Convention makes reference to awards issued in another jurisdiction without the qualification of international. So the scope of the Panama Convention seems to be shorter or more difficult to define. Also, the Panama Convention applies only to commercial transactions or to commercial awards, whereas the New York Convention has or lacks this qualification. Now, all these potential conflicts might not be relevant if these conventions were exactly the same. However, they are not. Many have criticized the Panama Convention, and there's an article written over 3 decades ago, but which I still consider to be very relevant, particularly for practitioners in the region. This article, which I strongly recommend you read, unfortunately, I cannot make a lot of reference to the article because of time, but I will quote it so that you search it, and if you want to write me an email, I can share it with you. It was an article written by Jan van der Berg. The title of the article is "The New York Convention of 1958 and the Panama Convention of 1975, Redundancy or Compatibility." And my conclusion from reading the article is that there's redundancy. Because of this, some practitioners, very prominent practitioners in the region, have proposed to denounce the convention. However, the convention still remains valid. But there's, when you read, and I invite you to read this article, you will note that there are some nuances to enforcement depending on whether the party opposing enforcement raises these nuances. I don't want to give you a guide of how to challenge an enforcement, but if you want to look at it, this article will give you some lights on the Panama Convention. Now, whether these differences have resulted in the failure to enforce an award, I'm not aware of any. There's one famous case, the Poligrafica case of 2013, by which the Colombian Supreme Court ruled on the residual nature of the New York Convention and ruled on the applicability of Article 7, which I was referring to. I also invite you to read this article, basically holding that in case of conflict between the New York Convention and the Montevideo Convention, then the conflict between both treaties would be resolved by Article 7, therefore applying the more favorable provision between the two treaties. So the answer to the question, considering this context, is yes, there could be problems. However, these problems have not materialized in failures to enforce, to my knowledge.
Thank you very much. That was actually very insightful. Some of those historical aspects that you gave from the Latin American region, I was not aware of. And, you know, it's so helpful that you have this at your fingertips. And, you know, what I understood from it was that in the 1970s, there was a regional approach, and then it moved on to a more global approach that Latin American countries took, and the compatibility aspect of it is actually quite enlightening. And the conclusion overall is that there are some dissimilarities, there are differences in the approaches and nuances between these three conventions, however, that that can easily be resolved. And you know, that leads me to the next question, which is regarding, you know, the courts. How well do Latin American courts and tribunals adhere to the spirit? We've heard you touch on your last comment about a case, so maybe you can give us the Latin American court approach to the spirit and intentions underpinning the New York Convention. How do they deal with these issues? Maybe you can cite a few cases that come to mind. Yeah, thank you.
Sure, absolutely, Leah. And I'm not aware of any problems resulting in failure to enforce award due to the alleged incompatibility or redundancy of the New York Convention and the Panama Convention. However, there could be. There are some provisions in the Panama Convention that may be problematic in its application, and this is why some practitioners have proposed this convention to be denunciated. I'll just give you one example. If you have an ad hoc arbitration, this is an arbitration not conducted under institutional rules and not administered by an institution, and you try to enforce an award, such award, based on the Panama Convention, you would probably find yourself in a surprising position, because under the Panama Convention, there is no ad hoc arbitration at all. Any ad hoc arbitration clause based on the text of this treaty should be administered under the rules of an institution constituted in Latin America. So you would have an incompatibility there. If you have an ad hoc award between countries, between companies based in countries that are parties to the Panama Convention, you have an award that should not exist because the ad hoc arbitration proceedings should not exist due to this remittance to this institution. And like those are some other aspects that could be problematic, but that to my knowledge, there has not been any instances thus far. Now, regarding how the Latin American courts have applied these principles or the spirit of the New York Convention or the New York Convention itself. In my view, there are two principal ideas underpinning the New York Convention with respect to enforcement of awards. First, the prima facie enforceability. This is the spirit to avoid the double exequatur, not having to prove an award's finality in the enforcement jurisdiction and then look to enforce it. And second, a restrictive and exhaustive, a list of restrictive and exhaustive grounds to refuse enforcement contained in Article 5 of the New York Convention. Now, in my opinion, Latin American jurisdictions are generally very good at adhering to both of these concepts. Mexico has an amazing track record, in my opinion. There are very few cases which I'm aware of that have been that have resulted in a failure to enforce the award. I cannot count more than 5. And there are many. So Mexican courts tend to be very restrictive in the application of these two underlying principles, particularly federal courts. And there have been some instances in which in the first instance, the decision is unfavorable to the party seeking the enforcement. However, this is later corrected in the appeal or in the amparos that are filed. Now, regarding some other jurisdictions, and I have to disclose that what I'm saying to you is not because I'm a practitioner in that jurisdiction, but I did some research. So there is a risk that the research I did is not updated. If that is the case, please let me know. But in Colombia, for example, there's 2 cases that are an exception to these underlying principles of the New York Convention. In 2011, the Colombian Supreme Court ruled in a case called Pollux Marine Services versus Colfletar. It's the Pollux case. The award was denied recognition. This was an award made in London, and the reasons for denying recognition was that the party failed to prove the award's finality as required under the Colombian Procedural Code. Now, of course, this deals with the double exequatur issue. Now, after Pollux, Colombia changed its arbitral law by implementing the UNCITRAL, a model, some provisions that resemble the UNCITRAL model law. Yet, in 2013, the same Supreme Court held in another case, the Poligráfica versus Colombia Tecnología case, that that specific case should be conducted as an exequatur because the foreign arbitral proceeding started before the law, this new law that adopted UNCITRAL. Now, in Colombia's defense, I'm not aware of any cases where Colombian courts have required a double exequatur of a foreign award after the implementation of the law 1563 in 2002, which is the one I'm referring, adopted this UNCITRAL model law approach. Now, with respect to the manner in which the grounds of Article 5 have been applied, there's another case, Petrol Testing versus versus Ross Energy. And here the Colombian court expressly stated that the defense relied on is a defense that was brought by the party opposing the enforcement, that defense was not expressly included in Article 5 of the Convention, and therefore that it could not be analyzed. So this is an excellent decision, basically recognizing the existence of Article 5 and the restrictive approach in its application. There's another case in Chile, EDF International, and I'm only making reference to cases that are an exception or a breach to the New York Convention. The EDF International versus Endesa. It's a 2011 case, and here the Chilean Supreme Court denied the recognition of an award issued in Argentina that had since been set aside at its seat. Now, relevantly, the Chilean Supreme Court rejected the enforcement on this ground, but also, and this is the relevant part, because the court considered that the award required a seal of approval or other sign of approval issued by a superior court of the country, which issued the ruling. So this was going beyond the requirements of Article 5 and required a sort of double exequatur. But generally speaking, if you go through the authorities, if you talk, well, in Mexico, I can assure you the principles have been observed. And in other Latin American jurisdictions, I think it's the same thing. There have been some issues or some concerns regarding amparos or acciones de tutela, which are constitutional challenges against the award. And some Latin American countries are dealing now with that. In Mexico, that was very quickly resolved, and there's case law saying that these constitutional challenges against arbitral awards are inadmissible. So overall, my conclusion is that yes, Latin American courts, specifically and more particularly Mexico, have adhered to the spirit and the intentions underlying the New York Convention.
Well, thank you very much, Adrián, for giving us that very wholesome perspective on Latin America. I'm glad we got out some bits and pieces about Mexico and other countries. Now, I'd like to jump to Dana and ask her, what is the U.S. federal court's approach towards the New York Convention, and if you can cite examples of where this has been, an exception, or there's a trend that you see, we'd be grateful to hear from you. Over to you.
Thank you, Leah, and thank you to the organizers of this conference. I think this is a fabulous, you're in your 8th year now, so congratulations, and particularly to the Harvard International Arbitration Law Students Association for putting this together. I've been a big fan of this conference, so thank you for including me as well. I thought I'd start by sort of drawing some of the distinctions with how it was described, done in Latin America with respect to the application of the New York Convention and the Panama Convention, and how the U.S. approaches deciding which treaty to apply. And I think that is largely framed by the implementation statute of the respective New York Convention and Panama Conventions. So just sort of at a high level, in the US, federal courts are very pro-enforcement with respect to arbitration awards, and I'm not sure that distinguishes the US that much from other parts of the world. But the case law is largely in federal court. And for those of you less familiar with the federal court system, we have our trial court is the district court, and then there's a court of appeals, appellate level, and then there's the Supreme Court. And it's the end of the line with respect to the review of a case, including an award enforcement case. It would be, we don't have the equivalent of amparo, although there are some sort of outlier exceptional procedures that can be taken that really don't usually come into play with respect to enforcing international arbitration awards in the US courts. So back to the implementing legislation. So the New York Convention and the Panama Convention are implemented in the US Federal Arbitration Act. And that is in what we call Chapter 2 for the New York Convention, Chapter 2 of the Federal Arbitration Act. And Chapter 3 of the Federal Arbitration Act implements the Panama Convention. And so when U.S. courts describe the grounds for confirming an award or addressing challenges to the award enforcement, we cite to the Federal Arbitration Act, where it implements the New York Convention as well as the provisions of the New York Convention or the Panama Convention, respectively, as well. With respect to the issue of potential conflict or which treaty applies to the enforcement of an award, if there's a conflict between the New York Convention the conventions are paramount. So if there's a conflict between the New York Convention and the federal statute that's implementing it, the convention applies. But that issue doesn't come up so much. But the issue of whether the New York Convention versus the Panama Convention applies, that is actually addressed very specifically in Section 305 of the FAA. And that says that international arbitral awards will be governed by the Panama Convention, where I'm looking at the quote, so I'm sorry to look away from you, where a majority of the parties to the arbitration agreement are citizens of a state or states that have ratified or acceded to the Panama Convention and are member states of the Organization of American States. So that's implemented in U.S. federal statutory law as 9 U.S. Code Section 305. And then where while there's much similarity, as we've already discussed, between the Panama Convention and the New York Convention, sometimes there's the opportunity for either treaty to apply to an award. And in that case, really it turns on if the majority of the parties are from Latin America versus not. And I have not, in my experience, seen the application of the Panama Convention in U.S. courts to enforce awards result in a different outcome than applying the New York Convention. And most of the case law in the U.S. is actually under the New York Convention. So, that takes us to Chapter 2 of the Federal Arbitration Act. So that sort of goes to the first issue that was discussed in the context of Latin America. So in terms of what issues come up most often in award enforcement cases, we have in the U.S. implemented the New York Convention and the Panama Convention, as I've said, but also there are grounds for a set aside in FAA Section 10 of the Federal Arbitration Act. And that those are set aside award grounds that are different from the grounds in the New York Convention to refuse enforcement of an arbitral award. There are many similarities, and I think for our purposes, it's easiest to focus on the grounds for non-enforcement under the New York Convention, because I think that actually while worded differently, there is a great overlap and interconnection between the grounds. So I think that one of the topics that we are going to be looking at a bit more closely together on this panel is the issue of public policy, and public policy being a ground for challenging or refusing enforcement of an award in a court for U.S. purposes today, a federal court in the U.S. and the extent of success or lack of success thereof and the arguments made thereof. And I would say that at a high level, there are many challenges under the public policy exception of the New York Convention, Article 5 2b, or the Panama Convention. But they very rarely, if ever, succeed. And to my knowledge, I've never known a case to succeed on that ground in the US. Although there are a lot of different ways to articulate a public policy ground, the standard is very high. And I think one thing we might come back to is how do different courts respectively interpret the meaning of public policy for the purposes of reviewing a challenge to an award on that basis. But I think I'll pause here and allow further dialogue and circle back more specifically on what the U.S. federal courts have said on that issue in a few minutes.
Thank you very much, Dana, for that introducing that aspect. And what I got from your presentation is quite interesting. The intersection between the Federal Arbitration Act and New York Convention, and how these are applied across the board in U.S. federal courts. And you, in the last comment, you mentioned public policy, of which I'd like to jump to Adrián at this point and ask him, in the Latin American region, how is the notion of public policy interpreted? If you'd care to give us a few examples from your experience, or if they're none, something that you've studied or researched on, that would be very helpful. Over to you.
Absolutely. Well, public policy is frequently used as a defense because it's a vague concept. And if you argue it well, you can put a lot of things into that concept, and it is the role of the court to distinguish what really is public policy and what it isn't. And generally speaking, I believe a majority of the courts have interpreted the notion in a very restrictive way. And there's a very important case in Mexico issued by the Supreme Court of Justice in 2016, around those days, probably 17. This is a case by a federal utility in Mexico, the Federal Electricity Commission, which is now a government company, a government-owned company, against an independent energy producer. And here, the dispute was governed both by commercial law and by administrative law due to the Mexican legal system and the subject matter of the dispute, which was the generation and distribution of energy. Anyhow, the Federal Electricity Commission lost the case. There was a very big award issued against the commission, and CFE sought the annulment before Mexican courts. Now, this is not an enforcement case. However, the grounds on which the annulment was sought were exactly the same as those established in Article 5 of the New York Convention involving public policy. Mexico has adopted the UNCITRAL model law, and therefore the grounds for annulment are very similar or identical to the grounds of non-enforcement under the New York Convention. Here, the main argument made by the Commission was that the decision rendered the award to undermine the continuity, reliability, and security of the Mexican electrical system, and therefore it was in breach of public policy. Now, the court clearly analyzed the issue and distinguished between what is a government policy and the manner in which it is implemented from public policy itself. And it ruled that a government policy should not be understood to be public policy for the purposes of annulment of awards. And here, this precedent, it's a 200-page precedent, quite large, but a lot of doctrine was established. First, it was confirmed or reconfirmed that domestic courts cannot analyze the merits of the award. Also, it ruled that Mexican judges must only evaluate if the arbitrator omitted certain norms or fundamental principles of law and whether these led to a clear and substantial violation of the norms in Mexico to justify the annulment of an award. And it went on further clarifying that an award would only violate public policy when the matter that is being resolved goes beyond the legal limits or beyond the limits of the state's legal institutions, as well as its norms and principle, and that the transgression, and this is very important, has to be severe. So it's not only a transgression, but a severe transgression. So from this ruling, you can see that in Mexico, the notion of public policy is applied very strictly for the purposes of either annulling or enforcing an arbitral award. In Colombia, for instance, a similar approach was taken. In the same case I was referring to in Petrol Testing of 2011, the Colombia Supreme Court noted that Article 5, Section 2B, which is public policy, was applicable only to violations of the most basic and fundamental principles of Colombian legal institutions. Sometime after, there was another case, the Drummond case versus Ferrovías en Liquidación, where the Supreme Court held a decision by holding that even if an award violates the rules of Colombian administrative law, such violation would not have triggered the public policy exception under the New York law. So a violation of administrative law does not equate to a violation of public policy. These are different things. And also there's a case, an interesting case in Argentina, de José Cartellone Construcciones Civiles versus Hidroeléctrica Narcotojónica. And in this case, the issue was whether compound interests specifically applied to a government agency were in breach of public policy or public order. And here the court determined that by granting compound interest in the arbitral award, which was the case, and it was therefore challenged on this basis, the arbitral award imposed an excessive burden on the award debtor, incompatible with Argentinian public policy, and thus its decision was unreasonable and disproportionate. Now, the issue of compound interests is complex. There are many jurisdictions that have declared that these compound interests are unconstitutional. So, and I can understand the reasoning behind this decision, but of course it's a controversial decision. But generally speaking, again, the majority of the jurisdictions in Latin America, I believe, with some exceptions, have interpreted the public policy exception in a very restricted manner.
Well, thank you very much, Adrián, for that insight. What I'm getting here is that nobody really knows, or nobody has defined what public policy is, but they do know what it's not. So it's very interesting. And perhaps, Dana, you'd like to weigh in on what has been described in the US as public policy or not. Over to you.
Thank you, Leah. And I think that your most recent comment is exactly on point, because the public policy exception, so to speak, is mentioned. Obviously, it's enumerated specifically in Article 5.2b of both the New York Convention and the Panama Convention, but neither of them define what is public policy. And also from a US perspective, the Federal Arbitration Act in Section 10 as a grounds to set aside an award does not expressly list violation of public policy as a ground to vacate an award. So we don't have that as a place to look for a definition of public policy either. However, in an international arbitration award enforcement proceeding, whose recognition or enforcement would violate public policy, that would fall within the Section 10 excessive powers ground for set aside. So you would actually capture public policy in a US set aside, but that still begs the question, how do you define public policy? And that is something that, we don't have closure on it, but we have a number of cases that have articulated it in very similar ways that gives enough case law guidance to understand the very high threshold that must be met to satisfy the public policy exception. So generally speaking, an award will only be refused for enforcement under the public policy exception if that public policy that's invoked is well-defined and dominant and ascertainable by reference to laws or legal precedents. And I think that sounds similar to what we heard in the context of Latin America, when you run up against a local law or a federal law or some provision in the governing legislation that may make an aspect of the award unenforceable. But that is very hard to meet. Particularly, U.S. courts have not really had occasion to rule definitively on that. But it is articulated as part of how you would define public policy in putting together the various phrases and portions of case law in the U.S. that have discussed the public policy defense, in usually ruling that it has not been met and the awards enforced. So other courts have said that the threshold for refusing to enforce under the public policy exception is, quote, extraordinarily high and extremely narrow. That's a federal court from DDC, the district court in Washington, D.C., involving a state sovereign, and in many cases, even commercial cases that result in international awards that are enforced under the New York or Panama Convention against sovereigns are heard in the Washington, D.C. courts. So that's sort of a go-to place for U.S. federal law jurisprudence on enforcing awards involving state sovereigns. But the most famous articulation, at least in my experience, of what the public policy defense means or how it is understood and defined is it would violate public policy if it would violate the U.S., quote, most basic notions of morality and justice. And that is recited over and over in U.S. federal case law involving the public policy defense. And that quote originally comes out of the Parson and Whittemore case, which I think many people have heard of, and that's a Second Circuit case from 1974. But that has been repeated in many, many federal court cases since, and it really is the best, I think, articulation of what is the public policy definition, so to speak, or the interpretation of the exception. I think it's also worth mentioning that the Secretariat of the UN Commission on International Trade Law Guide for the New York Convention states a definition, so to speak, or offers guidance on how to interpret the public policy exception. And it's described as a safety valve to be used in exceptional circumstances where it would be impossible for a legal system to recognize an award and enforce it without abandoning the very fundamentals on which it is based. And I think that that really echoes the definition or the description in the Parsons case, where it's described as something that would violate the U.S. most basic notions of morality and justice. And so it really goes to central tenets of the country's public policy, national public policy. And even though we are 50 states in the U.S., this isn't, when you talk about public policy, you're talking about U.S. national public policy. So I could talk about some cases that have considered it and rejected it, but I think that in the interest of time, I'll just sort of close by saying that, you know, even when a relevant public policy is identified, and I do think that there have been many cases that have brought relevant public policy concerns. They're not frivolous cases. They're simply not ultimately meritorious grounds on which to refuse enforcement. When they are raised, courts often find the public policy raised to challenge the enforcement of an award outweighed by the U.S. public policy in favor of encouraging arbitration and enforcing arbitration awards. And that sort of ties into something I started with earlier today, that the US is an environment that is very pro-arbitration and pro-enforcement. It does enforce the language of its implementing statute, the Federal Arbitration Act, to the letter strictly, and certainly if something were to rise to the level of public policy or otherwise, would refuse enforcement. So it's a pro-arbitration, pro-enforcement country, but within the limits and confines of the treaties to which it is signatory and the implementing statutes in our courts. So thank you.
Well, thank you very much for keeping it succinct. And, if we had more time, we would love to hear some of those cases. But it's very interesting that you brought us closer to a definition of public policy, and which is, as you said, does not violate US basic notions of morality and justice. And I think if there's one thing we'll get away from the public policy discussion, I think for me, that will be it. And so just to switch gears here and move to Adrián, we'd like you to address Mexico in particular, and in terms of, the laws that affect foreign immunity, and just if you can give us your experience as a practitioner and tell us how the laws on state and foreign sovereign immunity affect enforcement of awards in Mexico in particular. And then we can switch to Dana's view on this subject. Thanks.
Sure, absolutely, Leah. Well, first, let me begin by saying I believe, and I believe I have transmitted this, but Mexico is unquestionably a pro-arbitration jurisdiction. They favor enforcement of the arbitration agreement. They favor enforcement of arbitration award. The grounds for annulment are very strictly applied and are limited to those of Article 5 of the New York Convention, replicated in domestic law, the Commerce Code. So everything is perfect in that sense. Mexican courts tend to apply them in a very restrictive manner. However, one thing in which Mexico should be called upon, and this is an exception of how good the system is in Mexico, is when you try to enforce an award in Mexican courts before a government-owned company. There are many cases involving government-owned companies, particularly in the energy sector. I was talking a few moments ago about the Federal Electricity Commission, which has an enormous amounts of contracts that are subject to arbitration. And these are very large disputes. But we also have Pemex, the oil government-owned company. And there's a provision in the Federal Code of Civil Procedure, Article 4, that states that the assets of entities of the Federation cannot be subject to attachment. So if you have an award and you try to attach assets of CFE or Pemex or whatever other government agency you have an award against, under this article, you will not be able to attach assets. And this, of course, is a huge problem. This is why many parties go to New York or to someplace around the world to enforce arbitral awards against CFE and Pemex. This is why there's a famous Comisa case, and there's other cases that have where the awards have that are completely domestic, and the enforcement is being sought in a different jurisdiction in Mexico. So there's also in parallel to Article 4 of the Federal Code of Civil Procedure, there's also Article 13 of the General Law on National Property, which in line with what Article 4 of the Federal Civil Code of Procedure says, there are assets of the dominio público, and the definition of these assets of the public domain is unclear, and one could interpret that all assets of CFE and Pemex are part of this dominio público. So again, it's very difficult to identify assets that are actually attachable. So the award in Mexico lacks a little bit of relevance. Now, having said this, there are two remarks I would like to make. First, Mexican law is contradictory with respect to how it treats the Mexican state and how it treats foreign states. There's case law about the immunities on foreign states. And here, the traditional distinction between public assets and commercial assets, public or government activities, and commercial activities performed by the government is fully recognized and fully enforced. And one can attach assets before Mexican courts of foreign states doing business or commercial activities in Mexico. But you cannot do that against the Mexican government. And this brings me to so this is a contradiction that is difficult to sustain in my perspective. But this brings me to my second remark. I believe this absolute prohibition of attaching assets is unconstitutional. However, for some reason or the other, so far, there's no pronouncement by Mexican courts on whether Article 4 of the Federal Code of Civil Procedure and Article 13 of the General Law on National Property are unconstitutional. Fortunately, we now at the firm have one case in which this unconstitutionality is being argued. It will take some time for there to be a final judgment on the issue, but hopefully, if everything goes as it should go, these provisions will be declared unconstitutional because the prohibition is because of the absolute character of the prohibition. It doesn't comply with the constitutional requirement of any distinction between private and government entities being proportional. So here, the proportionality requirement under the constitutional analysis is not, in my opinion, complied, and we will see how this case is ruled upon. So in short, the immunities regime in Mexico is very aggressive in favor of the Mexican government, is very standard with respect to foreign governments. However, this absolute provision applicable to the Mexican government may be, or is, in my opinion, unconstitutional, and possibly we would have a judgment recognizing this in the future.
Well, thank you very much, Adrián. Now I would like to switch to Dana, if she can give us a few minutes, a high-level overview of the treatment in the US and also then I'll switch back to you, Adrián, for your final comments, if any, on this topic, and Dana as well, and then we switch back to the organizers.
Thank you. I'm conscious of time and that we have a fantastic keynote coming up at the bottom of the hour, so I will be brief. The issue of enforcing an arbitral award against a foreign sovereign is a very hot topic always for obvious reasons. And in US courts, it is necessary to identify a basis as to which to proceed against a foreign sovereign under the Foreign Sovereign Immunities Act. So with respect to enforcing an arbitral award against a sovereign that is a named party in the arbitration, typically there are two grounds that are invoked as a basis to be able to proceed against the foreign sovereign under the Foreign Sovereign Immunities Act. And that is, well, I'm not going to give you all the statutory numbers, but it is the what we'll call subsection 1, the waiver/consent basis, which means where the foreign sovereign is a party to the arbitration, it has waived its immunity, and that is typically found in the arbitration clause or the contract containing the arbitration clause, and then the participation in the commercial arbitration. I'm trying to speak here about commercial arbitrations and not sort of weave between investor state arbitration and commercial arbitrations. So this is still in the context of the New York Convention and the Panama Convention. And then the other arguably more used ground to find an exception to the immunity granted in the Foreign Sovereign Immunities Act for foreign sovereigns is what's called the Arbitration Exception. And that's where the state has agreed to arbitrate and has arbitrated. So that's, I think, 1610.8.6 or something. So those two grounds are typically the grounds that are asserted by the other party, the claimant or the prevailing party in the arbitration, seeking to enforce an award in U.S. federal courts against a foreign sovereign. That is for confirmation of the award in order to turn the award into a U.S. judgment. There's additional steps and provisions in the Foreign Sovereign Immunities Act that relate very specifically to proceedings to attach or collect upon the award. And I think that that was part of what was being discussed, that, there are issues as to, how you are able to access a foreign sovereign's assets and I guess in some circumstances, whether there's consistency between doing that with respect to a foreign sovereign and a U.S. sovereign. In the interest of time, I'm not going to get into that debate, but I would highlight that there are some important provisions in the Foreign Sovereign Immunities Act with respect to enforcing, collecting on a judgment or an award issue, that leads to a judgment in the U.S. And in the interest of time, the focus really is on commercial assets that are being used commercially within the United States that are not immune because they are being used solely for the purposes of sovereign acts and nothing to do with commercial. So there's a lot of focus on the role of the government and government entities in the commercial realm in the U.S. when looking to collect against in the U.S. against sovereigns. Conscious of time, I'm going to turn it back over to Leah and let her lead us forward from here.
Well, thank you very much to our panelists, Adrián and Dana. This has been very most useful, especially for me coming from the ICSID and investor state dispute settlement, where it's a one-stop shop. It's a self-contained system. So learning the different approaches has also been very useful for me. And I think we have 1 minute left, I think seconds. So I'm just going to hand over to Karim on behalf of this panel. We just want to thank you for this opportunity to be with fellow students and other esteemed guests of this arbitration conference, and look forward to next year when we can do this again. Thank you.
Thank you very much, Leah, Dana, and Adrián, for this truly fantastic and thought-provoking panel. It was very enlightening hearing your discussion on the enforcement of awards in the US, Mexico, and other Latin American jurisdictions. Now we will proceed with the final keynote speech of the 8th Harvard International Arbitration Conference, entitled Investment Arbitration at the Crossroads of Civil and Common Law, that will be delivered by Dr. Claudia Anaker. Let me very briefly say a word about Dr. Annaker's background. Dr. Claudia Anaker is partnered at Dechert in the Paris office, where she focuses her practice on international arbitration and litigation and public international law issues, including investor-state disputes, interstate disputes, disputes involving international organizations, and human rights cases. She has represented states and investors in more than 30 different international treaty arbitrations. Dr. Annacker also acts as an arbitrator. She, in fact, was appointed to the ICSID panel of arbitrators in 2020. She is also an adjunct professor of the University of Vienna, where she teaches advanced research seminars on international responsibility and international dispute settlements. Without further ado, Dr. Annacker, the floor is yours.
Thank you very much, Sebastian. Good afternoon. I'm very pleased to see so many people participating to address you today on the topic investment arbitration at the crossroads of civil and common law. Our investment arbitration has traditionally been shaped by both civil and common law traditions. Let me begin with a few examples of basic principles whose application by investment tribunals illustrates the hybrid approach that characterizes the investment arbitration system. Now, my first example is the doctrine of inherent powers. The doctrine emerged from the practice of English courts, and it has been adopted by many common law jurisdictions. Now, in international law, it was first relied on in the 18th century by mixed claims commissions constituted under the Dechert Treaty, a treaty concluded between two major common law countries, the United States and Great Britain. Our investment treaty tribunals have broadly accepted and applied the concept. One example are orders for security for cost, a type of inherent power that is well established in common law jurisdictions but little known in civil law countries. Other examples are the powers assumed by investment treaty tribunals to address abuse of process or to permit the participation by non-disputing parties. Now, discretionary inherent powers are also expressly reflected in the ICSID Convention and the ICSID arbitration rules. Now, Article 44 of the ICSID Convention requires ICSID tribunals to decide any question that is not covered by the convention, by the rules, or any rules agreed by the parties. And ICSID Arbitration Rule 19 requires the tribunal to make the orders required for the conduct of the proceedings. Now, these provisions are declaratory of an ICSID tribunal's inherent procedural powers. Now, ICSID tribunals have even invoked the doctrine of inherent powers to displace restrictions imposed by the ICSID Convention. Now, invoking their inherent powers, ICSID tribunals have held that provisional measures are binding on the parties, even though Article 47 of the ICSID Convention, by its express terms, authorizes them only to recommend provisional measures. My second example is a principle that primarily derives from civil law, the concept of res judicata. The traditional civil law approach to res judicata requires triple identity. Identity of the parties, of the subject matter, and of the cause of action. The triple identity test was first introduced into international law in 1927 by Judge Ancelotti in his dissenting opinion in the Kosovo factory case before the Permanent Court of International Justice. It has since been endorsed by numerous investment treaty tribunals. But some investment tribunals have also applied the related common law notions of collateral estoppel and of claim and issue preclusion. These tribunals have included two or more common law arbitrators, and they have applied these concepts in the context of abuse of process. to prevent related parties from relitigating claims based on a similar set of facts. I now turn to substantive investment treaty protections, and specifically the fair and equitable treatment standard, the protection most often invoked by investors and most often found to have been violated by investment treaty tribunals. The standard is an expression and part of the good faith principle, which in its origins is a civil law concept, being included expressly, for example, in the French and German civil codes. Two important elements of that standard are the protection of a foreign investor's legitimate expectations and proportionality. Both concepts were developed in civil law jurisdictions, in particular in German administrative law. They are also well established in European Union and European human rights law. Now, the principle of legitimate expectations is also recognized to some extent in common law. But the principle of proportionality remains controversial, both in common law and in investment treaty arbitration. The United States has traditionally opposed the proportionality principle as not forming part of the minimum standard of treatment. But the leading case in investment arbitration on proportionality, Occidental versus Ecuador, relied heavily on this principle to find a violation of the FET standard of the United States-Ecuador BIT. On the ground that the state's termination of a contract was a disproportionate response to the claimant's contractual breaches. The tribunal was composed of one civil law and two common law arbitrators, and it was established under a BIT between a common law and a civil law country. And it applied the proportionality principle as being, quote, very well established in a number of European countries and having been applied countless times by the European Court of Human Rights and the European Court of Justice. It did so to resolve a dispute between common law claimants and the South American civil law respondent state. These are just a few examples of the crossroads of civil and common law in investment arbitration. I will now turn to the role that the crossroads play in the decision-making process of investment tribunals. Let us start with the concept of precedent. When it comes to precedent, investment treaty arbitration is necessarily closer to the civil law tradition. There is no system of precedent. Like other international courts and tribunals, investment treaty tribunals are not bound by prior decisions and awards. And this is inherent in the very nature of the current investment treaty arbitration system. Our investment treaty tribunals do not operate in a hierarchical or unitary system. They are constituted ad hoc to decide a particular dispute inter partes under a particular investment treaty. As a result, the investment treaty tribunals have rendered varying decisions on key issues. The diverging approach of investment treaty tribunals to the interpretation of umbrella clauses is a prime example. An umbrella clause requires the host state to observe any obligation it has entered into with respect to a foreign investment. Now, investment treaty tribunals have disagreed on the correct interpretation of nearly every aspect of this clause. Whether an umbrella clause elevates purely contractual breaches to treaty breaches, whether an umbrella clause only protects against sovereign conduct, whether the host state and the investor must be in privity, whether the umbrella clause applies to unilateral or general statutory commitments, and whether contractual dispute resolution clauses are umbrella clauses under investment treaties. The Ancillary Working Group on Investor-State Dispute Settlement Reform has identified no less than 24 areas in which investment treaty tribunals have issued inconsistent or even contradictory decisions, including, for example, the principles regarding damages discussed earlier today. Now, in this regard, investment treaty tribunals have expressed quite different views of their mandates. At one end of the spectrum, the tribunal in Romak versus Uzbekistan considered its mandate to be essentially the same as that of a commercial arbitral tribunal. Now, it described its mission as, and I quote, not having been entrusted by the parties or otherwise with a mission to ensure the coherence or development of arbitral jurisprudence. The tribunal's mission is more mundane, but no less important: to resolve the present dispute between the parties in a reasoned and persuasive manner, irrespective of unintended consequences that this arbitral tribunal's analysis may have on future disputes in general. Close quote. At the other end of the spectrum, the tribunal in René Rose Lee versus Peru referred to, and I quote, its duty to contribute to the harmonious development of investment law and thereby to meet the expectations of the community of states and investors toward certainty of the rule of law. Close quote. In practice, although there is no doctrine of precedent in investment arbitration, awards are routinely referenced as persuasive authority by counsel and by tribunals. Our investment treaty tribunals generally also accord significant weight to a consistent line of cases, similar to the jurisprudence constante or ständige Rechtsprechung approach in French and German civil law. Investment tribunals have, for example, relied on consistent lines of cases to confirm that expropriation requires substantial deprivation of the rights represented by or the value of an investment, that a breach of the fair and equitable treatment standard does not presuppose bad faith, or that the standard of full protection and security does not imply strict liability. Let us now turn to the principle Jura Novit Courier, or better, Jura Novit Arbitral. Is this principle applicable in investment treaty arbitration, and if so, how is it applied? The principle is well established in civil law jurisdictions. Sir Francis Jacobs, former Advocate General at the European Court of Justice, summarized the main aspects of this principle as follows. First, a court in the continental systems is deemed to know the law. Second, it must apply the appropriate legal rules to the facts as they are presented by the parties. And third, if necessary, it will engage for that purpose in its own legal research. Now, the mainstream position in common law, by contrast, is that the principle Jura Novit Courier is not applicable. In the words of the late Lord Steyn, by and large, courts of law in our system are the hostages of the arguments developed by counsel. On Courier, international jurisprudence aligns with the civil law tradition. In Fischer's jurisdiction, Federal Republic of Germany versus Iceland, the International Court of Justice confirmed that, and I quote, the court as an international judicial organ is deemed to take judicial notice of international law and is therefore required to consider on its own initiative all rules of international law which may be relevant to the settlement of the dispute. Close quote. Investment treaty tribunals, however, tend to limit themselves to the legal arguments presented by the parties. Only a few tribunals and ad hoc committees have addressed the power of an investment treaty tribunal to conduct its own legal analysis. Several tribunals and ad hoc committees have confirmed that investment treaty tribunals do have Courier powers. The Patrick Mitchell and Keynote committees, for example, held that ICSID tribunals are entitled, within certain limits, to apply a rule that the parties have not invoked in the arbitration. A few tribunals, mainly composed of civil law arbitrators, have considered that they are not only empowered, but actually required to apply the law on their own motion, irrespective of the positions of the parties. In line with the jurisprudence of the ICJ, the tribunal in Casinos, Austria versus Argentina noted, and I quote, in its analysis of the governing law, it is not limited to the arguments or sources invoked by the parties, but is required under the maxim Jura novit Courier, or better Jura novit Arbiter, to apply the law on its own motion. To support this requirement, the tribunal referred to its, quote, public function as an adjudicatory body that is part of the administration of international justice. But there are also ad hoc committees that have held that tribunals are not bound to conduct their own legal analysis and research. The Vivendi Committee, for example, quote, firmly confirmed its view that a tribunal is not required to address interpretation issues not raised by the parties. While some investment treaty tribunals have endorsed the principle that they may apply the law ex proprio modo, and a few have even considered themselves bound to do so, investment treaty tribunals have generally been reluctant to go beyond the legal arguments submitted to them. More in a common law manner, many investment tribunals defer to the legal arguments and to the authorities that the parties present. The criticism of this approach has been pointedly summarized by Professor Paulsen. A tribunal in an investment dispute cannot content itself with inept pleadings and simply uphold the least implausible of the two. Let us now turn to the procedural crossroads of civil and common law in investment treaty arbitration. What role does the common and civil law divide play in influencing the arbitral rules commonly applied in investment arbitration and the approach of investment treaty tribunals in managing arbitrations? Drawing inspiration from each of the civil and common law traditions, investment arbitration has developed into a sui generis hybrid system with both common law and civil law features. In practice, the procedure is closer to a common law-like adversarial procedure. While several common law features are significantly curtailed, it is up to the parties to present their case. It is up to the parties to submit witness and expert reports and examine witnesses and experts at the hearing. Investment arbitrations typically also feature document production, but unlike US-style discovery, the exercise is limited to requests for specific documents or narrow categories of documents that are material to the outcome of the case. The common law concept of depositions of witnesses, however, is virtually unknown in investment arbitration. This hybrid approach is reflected in both the arbitral rules commonly applied in investment arbitration and arbitral practice. What are the reasons for this hybrid approach, combining civil and common law elements? As is the case in commercial arbitration, this is partly due to the balanced compromise that the applicable arbitral rules and guidelines such as the IBA rules on the taking of evidence in international arbitration purposely strike between common law and civil law traditions. But the hybrid approach is also due to the diversity of actors in investment arbitrations. Now, empirical data suggests that around 58% of arbitrators in investment arbitrations have a civil law background, and surprisingly, only about 33% have a common law background. But around 22% of arbitrators sitting in investment arbitrations have a background in both civil and common law, mostly lawyers educated and trained in civil law who continue their studies with LLMs in common law jurisdictions. Most claimants in investment arbitration are also from civil law jurisdictions. And among the claims brought against the 15 most frequently sued respondent states, more than 85% have been brought against civil law countries. However, a clear majority of counsel representing both investors and respondent states come from common law jurisdictions. Now, let us now take a closer look at how the hybrid approach is applied in practice. Now, in terms of written pleadings, the standard practice reflected, for example, in the ICSID arbitration rules represents a middle ground between common and civil law procedures. The parties file a memorial and counter memorial, typically followed by a second round of written pleadings. In line with the civil law practice, it is the respondent who is given the final word. There is also a trend, again closer to the civil law tradition, to require claimants to specify their claims early in the proceedings, or even before their initiation. Recent investment treaties and investment chapters of free trade agreements require investors to serve detailed notices of dispute before they may initiate arbitration. For example, under the Australia-China Free Trade Agreement, a notice of dispute must identify the measures giving rise to the claims and the treaty provisions alleged to have been breached, set forth a brief summary of the legal and factual basis, and specify the relief sought and the appropriate amount of damages. Now, the amendments to the ICSID arbitration rules, which will enter into force in July this year, follow this trend. I now turn to witness and expert testimony. in investment arbitration. Now, in line with the common law approach, it is typically up to the parties to offer witnesses and to retain experts to provide support for their positions. While investment treaty tribunals have the inherent power to appoint their own experts, and procedural orders often expressly authorize them to do so, investment tribunals have made little use of this power. They have appointed their own experts in only about 20 cases. Now, in most of these cases, investment tribunals appointed experts on specific technical or legal issues where the parties had already proffered their own experts. Now, again, in line with the common law approach, it is also up to the parties, not the tribunal, to examine witnesses and experts at the hearing. While tribunals may put questions to experts and witnesses, they often limit themselves to clarifying testimony during or after examination by counsel. Tribunals may also call witnesses and experts on their own volition, but it is not common for them to do so. Now, this practice contrasts with that of the Arrhenius Claims Tribunal. The Arrhenius Claims Tribunal followed more the civil law approach of questioning fact and expert witnesses rather than allowing the parties to engage in direct and cross examinations. The evidential value accorded to witness testimony by investment treaty tribunals also strikes a middle ground. Now, in civil law jurisdictions, testimony by interested parties is generally not considered reliable, while such testimony can be fully probative in common law jurisdictions. In investment treaty arbitration, interested parties such as the claimant company's management, employees, or individual shareholders routinely provide testimony. In line with the practice of the Arrhenius Claims Tribunal and closer to the common law approach, such testimony may be given less probative value, but it is often accorded substantial weight. On the other hand, some investment tribunals have admitted hearsay evidence and freely assessed its weight, while such testimony is generally inadmissible in common law proceedings. Document production is another area where investment arbitration takes a middle ground. Most investment arbitrations do feature document production, often in extensive form, but in accordance with the IBA rules on the taking of evidence, which are widely used as guidelines by investment tribunals, common law style discovery is excluded in investment arbitration. Now, let us finally review the practice regarding Amicus Courier or non-disputing party submissions. Amicus Courier submissions first appeared and are now frequently used in common law proceedings. Civil law courts have historically been more reluctant to accept such submissions, but some civil law countries, France for example, have recently amended their codes of procedure to allow them. Now, in investment treaty arbitration, Amicus Courier submissions were first allowed in 2001. In the NAFTA arbitration Methanex versus United States, opposing parties from common law jurisdictions before a tribunal composed of 3 common law arbitrators. Now, that case concerned a challenge of a ban that California imposed on a gasoline constituent, which raised important environmental and health issues. There is a growing trend in investment arbitration to allow non-disputing party submissions. To date, investment tribunals have accepted more than 60 Amicus Courier submissions from NGOs, intergovernmental organizations, states, as well as private parties. Now, in Bywater Gulf versus Tanzania, for example, 5 NGOs were allowed to make submissions on the human right to clean and safe water. Among them, the Center for International Environmental Law and the Legal and Human Rights Center, an NGO based in Tanzania. This trend is also reflected in the ICSID arbitration rules and other arbitral rules specifically tailored to investment arbitration, such as the Vienna Investment Arbitration Rules or the SIAC Investment Arbitration Rules. Each of these rules expressly authorizes investment tribunals to accept non-disputing party submissions. In addition, the Vienna and the SIAC investment arbitration rules and the amendments to the ICSID arbitration rules authorize states or international organizations that are party to the treaty providing consent to arbitration to file submissions on questions of treaty interpretation. Now, this expanded use of Amicus Courier submissions in investment arbitration has been characterized as a victory of common law over civil law traditions. However, such use may be less a common law victory than a reflection of the special nature of investment arbitration. Investment arbitration involves public interests, such as environmental protection, public health, taxation, or the stability of the host state's financial system. Now, these public interests justify the intervention of non-disputing parties, and their intervention also furthers transparency, which, due to the public interests at stake, plays a much greater role in investment arbitration than in commercial arbitration. Now, this brings me to my final point. Is the current predominantly adversarial approach in investment arbitration, which largely defers to the parties to present their case and evidence, the best fit for investment treaty arbitration? Our investment treaty tribunals decide disputes involving the exercise of the state's sovereign authority, its legislative, executive, and judicial powers. Unlike commercial arbitral tribunals, investment treaty tribunals are in essence called upon to decide challenges to administrative acts, legislation, and court decisions. Outside the investment treaty arbitration context, a more inquisitorial approach is generally adopted for challenges to sovereign acts, both at the domestic and at the international plane. Precisely because of the public interest at stake, it is generally not left to the parties' discretion to choose the legal and factual issues to be decided and to select the evidence and the legal authorities on which the court or tribunal should rely to resolve the challenge. In civil law jurisdictions, the concept of burden of proof is not applicable in proceedings involving challenges of legislative or administrative acts. Constitutional and administrative courts may not simply defer to the party's position or to the evidence they have adduced. The courts are required to take an active role, both in establishing the facts and the law. Now, even in some common law jurisdictions, judicial review proceedings tend to have inquisitorial rules, irrespective of whether they are subject to the rules of civil procedure. Under English law, many claims in the field of administrative law are heard by special administrative tribunals in proceedings that are more inquisitorial than those in general courts. Now, actions challenging acts of the EU institutions before the General Court and the Court of Justice of the European Union are also heard in inquisitorial proceedings. The General Court and the CJU are not bound by the arguments advanced by the parties. They may raise public policy issues on their own initiative, public policy being defined widely to include, for example, lack of competence. And they may request further evidence in addition to that introduced by the parties. Similarly, arbitral tribunals hearing interstate disputes have commonly conducted their proceedings in a more inquisitorial manner. In several recent interstate arbitrations, the tribunals have appointed their own experts and proactively requested evidence from the parties. This was the case, for example, in the maritime boundary limitation arbitration between Guyana and Suriname. This was also the case in the Indus Waters Kishanganga arbitration under a water distribution treaty between India and Pakistan. A recent initiative, the 2018 Prague Rules on the Efficient Conduct of International Arbitration, proposes to align international arbitration with the examples I have just given, by substantially tipping the balance in favor of the civil law inquisitorial approach, encouraging the tribunal and the parties to avoid any document production, promoting a proactive role for tribunals in establishing the facts, explicitly authorizing tribunals to apply legal provisions not applied by the parties, and expressing a preference for documents-only proceedings. The Prague Rules would do away with well-established features of the hybrid approach. That approach is apparently appreciated by users of investment arbitration. Indeed, even one of the drafters of the Prague Rules cautioned that the adversarial approach remains appropriate when a case is, quote, complex, fact-heavy, and has a lot at stake, which is typically of investment treaty arbitrations. Now, time will tell whether the Prague Rules will have any impact on investment arbitration. My prediction is the hybrid system will prevail. Now that completes my presentation. Thank you for your attention. I hope to be in contact with you in the future. I would also like to thank my co-chairs and each of our panelists for their contributions and insights. And I would like to extend my special thanks to Karim and Sebastian for putting together such an inspiring conference program and making this conference work so smoothly. Thank you.
Thank you so much, Dr. Annacker, for this excellent comparative presentation. And it was the perfect way to wrap up this two-day conference, as also digged deeper into some topics that the panelists have touched upon. So thank you so much for that. And on behalf of the entire board of the Harvard International Arbitration Law Students Association, I want to thank you once again for accepting our invitation and co-chairing this conference. And we look forward to hosting you in upcoming HIALSA events in the near future. We've reached the end of our two-day Harvard International Arbitration Conference. And I will introduce to you Marianne Hassan, who is the president of the Harvard International Arbitration Law Students Association and a current LLM student at Harvard Law School. And Marianne will be giving the closing remarks for the conference. Thank you all for attending the 8th Harvard International Arbitration Conference, and we hope to see you again next year.
Thank you very much, Karim. And thank you very much to Dr. Anaker for her insights. And it is quite amazing to actually see your heroes and your legends on our platform as well. So thank you very much to everybody for their help. So good afternoon and good morning and good night to everybody who's joining us from around the world. Again, as Karim has said, many thanks for joining us for the 8th Harvard International Arbitration Conference. I would like to first again thank our 3 co-chairs, Dr. Claudia Anaker, Dr. Dietmar Prager, and Dr. Mohammed Shelbaya. I would also like to thank our sponsors, White & Case, the Boys in Blimpton, Courier Gottlieb, Covington, and Chavez. And Wobeser. So I would also like to thank our institutional supporters and our broadcaster, international, the Arbitration International channel. And I would like to thank our stellar conference team, Sebastian and Karim. Considering COVID, this conference has required a Herculean undertaking, and these 2 gentlemen have done a brilliant job bringing together such esteemed guests from all around the world. As a practitioner myself, I just wanted to offer one reflection. I consider myself a third culture kid, and I think back when I first fell and became intrigued by and fell in love with arbitration. I'm Somali, East African, and our hair arbitral system requires the use of elders, and these disputes are handled through a redemptive arc, one of compensation, and it's not punitive. I remember seeing elders handle complex disputes to opposing parties, then go on, laugh, and break bread. And this form of dispute resolution, whilst now it's so sophisticated and high stakes, as we know, across international fora and handled primarily by international law firms, we must remember that disputes are still very much handled under the shade of trees in countries like mine and in local communities. And I think that's pretty magical. So this theme and the conference very much highlights how broad arbitration is, the cultural norms and the rich legal traditions that have shaped the practice and jurisprudence. This is also really reflected in our board. We have such an international executive board from all around the world. And I think that that has very much inspired our programming for this year, including the conference as well, and panels and discussions. If I may, I would like to just close this by sharing a comment made to me by the late, great Professor Emmanuel Gaillard in 2016. At the time, I was working as a state representative, and I was unsure of whether or not I'd made the right decision and whether I should have actually gone and stayed in international practice at an international law firm. And what he said to me struck with me, which was arbitration really is what you make it. There is no one route to a successful career in arbitration. And I think that's what makes arbitration so special. You can be in academia, you can be in policy, and you can be in practice. And so I think what I'd like to share with our participants around the world and to everybody watching is that your contribution is valued. And ultimately, everybody has a place in arbitration and everybody is welcome. What I do hope for is that the continued conversations surrounding diversity continue, and that HIALSA can also be a part of that conversation, which we'll hopefully be doing in the next coming weeks with some of our final events. So once again, I'd like to thank you for joining us, and I hope to see you all again next year. Again, I'd really like to thank my team, Karim and Sebastian, our 2 magicians, and it's really been an honor to work with both of them this year. Thank you all for joining us, and I wish you a wonderful remainder of the afternoon. Thank you.